everybody, I'm Dan Shores. Thank you for attending the State of Partnering Innovator IP Bootcamp. I'm here, I'm a partner at Rothwell Figg, and I'm here to talk about advanced IP strategies for emerging biotechnology companies. I'm looking forward to our discussion today. So as we kick this off again, I'm a partner at Rothwell Figg. I represent emerging biotechnology companies here in our Boston office. We have a DC office as well. Our home office is in Washington, DC. We've been there for about 40 years. We have a very strong interdisciplinary practice. And we also have a Boston office that we opened in March of 2019 that I work out of. My practice, I focus on developing IP strategy for emerging companies, emerging biotechnology companies, other emerging companies as well. And we're going to talk a lot about why, what types of things that emerging companies need to do with respect to IP, what the considerations they should take into account. And I'm involved directly in those types of matters. They include building patent portfolios, negotiating strategic collaborations. Ultimately, you're in a business and you want anything that you do, especially as an early stage company, anything that you do, you want it to align with what your business objectives are. And IP strategy is very important to that. And that's what that whole process, and you really want your IP strategy to align with what you're trying to accomplish as a business. And I'm very well aware of that. We at the firm are well aware of that, how you want to align your IP strategy with your go-to-market, your funding, your exit. And again, today we're going to talk about a lot of those issues, and you can see how integral IP is to a lot of different facets of your business and your commercialization that perhaps you weren't necessarily aware of before today. Rothwell Figg, again, we're a very long-standing, strong intellectual property firm. We believe in our clients. I believe in my clients and the power of their ideas. That's what this is all about. The innovation that we experience, and anyone that's on this webinar right now, knows what I am talking about, especially in our ecosystem here in Massachusetts, and particularly in the Boston and Cambridge area. I mean, this is why we go to work every day. Innovation. We're trying to make the world a better place, and it's something that I believe in, and we as a firm believe in, and that's really kind of the spirit that I approach working with emerging companies. That's the spirit I bring to the table. Most of the people here, I'd imagine, are working in a team that's in a specific area, specific space. And I like to reflect a little bit on the different innovations that have come out of teams over the course of the years. I prepared this slide just as some examples of innovators over the course of the last 150 years or so. And the innovators are, bringing things and companies into the world that really have changed people's lives, have made the world a better place. Those technologies vary, certainly, and their major advancements in the biotech space are very important and very pertinent here. Also note that, and for this conversation, but also note that most, if not all of these technologies and were started off with teams that maybe weren't the most well-funded. I mean, I think the Wright brothers is the prime example. The Wright brothers were competing. They were in a space for first in flight, and they were competing against another another team that was very well-funded. The Wright brothers were funding their company through the sales in their bicycle repair shop, but they were first. And I think that's pretty exciting and a sort of exhibit A for the types of companies and sort of the spirit of the emerging companies that we work with and really enjoy working with. And I'm sure many of you in the audience here can identify with that story and a lot of the other stories that are behind here. And obviously this is a non-exhaustive overview, but it's inspiring, I think. And one of the most recent advancements that we've seen is in the mRNA based therapies that some of the core science that was developed were from Doctors Carrico and Weissman at the University of Pennsylvania. Now, and that was back in I think it was the mid 2000s, 2005, when they first wrote a paper for using mRNA therapies for mRNA for therapy. And now in 2020, the black swan event of the COVID-19 pandemic opened the door and ushered in the opportunity for mRNA technologies to get into the world, and it's a pretty amazing advancement. And so I think that's pertinent. But perhaps the most exciting square here, or image or view here, is what's next. There's something that's next, and that's really kind of the exciting part. And there's a lot of problems to solve in the world. There's a lot of healthcare issues and needs that need to be met, and that's what really sort of gets me up in the morning, gets me going, is working with early stage companies to advance science, translate science, and to make that science into a commercial reality to help people and to help the world. Factually about Rothwell Figg, we're a long-standing IP powerhouse. We've been doing it for about 50 years now, and we have a very strong team, as I mentioned at the outset, about 40 to 45 lawyers, and we are attorneys, obviously, but we're also scientists. We're also engineers. I am an engineer by education and training, and so we have a strong group of folks that with those backgrounds, and we also have an interdisciplinary IP practice. And so we have the expertise on the spectrum of technologies, from biotech, med device, chem, tech, AI, which we're seeing a lot more of that now, utilizing artificial intelligence for drug development, for example. We're seeing those two spaces really come together, and which is pretty amazing. And I think that's going to be a major growth area for many years to come. And we also handle other technologies as well, material science, energy, really the full spectrum. So we bring that to the table in terms of technical expertise. And we also, with regard to our legal expertise, we have an interdisciplinary practice there as well. And all the way from patent protection, advising on trade secrets, securing trademarks for branding, licensing, litigation, privacy, a lot of issues that come up during the life cycle of any company, including an early stage or emerging company. We handle that, and we'll get into a lot of the sort of details about the types of issues, IP issues that can come up, particularly in the early stages of a emerging biotechnology company. But just giving you a sense that this is our wheelhouse and what we handle on a routine basis, and we're very, very, very passionate about it as well. And I think I covered this to a large extent, the fact that we serve emerging biotechnology companies. We also understand what that means, and we understand the needs of our clients. And cost is usually a significant issue. We have service packages, including our guided application, guided patent application approach, where we will work with our clients to guide them through the patent application process, which gives the client more ownership over the patent application, but also it reduces costs. So the guided application process is something that we routinely apply to our early stage clients. We also have fee flexibility depending on the circumstances of each one of our clients. we work with our clients to help achieve their goals, understanding that there are a lot of challenges relative to their funding. We also understand that the challenges of when there is funding, where to spend those funds, and we get in the trenches and with our clients, and also understand what our clients go through, and that's something that we offer, and in terms of our approach to fees and other things as well. I mean, we're there as a valuable team member, and we're there to add value to the process. So we take that very seriously, like our other things I mentioned earlier. And we're very passionate about helping our clients win. That's primarily what I personally get excited about. Is I want to win. I want my clients to win, and together, that usually happens in many different forms. And so just wanted to communicate that to the audience before we get into the detailed IP issues. The last item for the firm is we have a new, not relatively new, we launched a blog last quarter, the quarter 4 of 2020, and the blog is called RF Emerge. It's geared toward emerging companies. There are resources on the blog relating to core issues that emerging companies face. There's also information on trends and analyses in the space, emerging company space broadly, and this isn't specific to a particular tech area. There's certainly a good amount of content relative to biotechnology, but there are also other technologies that we cover on the blog. We also list out legal developments as well. So feel free to check us out on rfemerge.com or on our website, rothwellfigg.com, and let me know if you have any questions. So let's get into the subject matter that we came here to talk about, which is intellectual property strategies for your emerging biotechnology company. So let's sort of talk about basics first. What is intellectual property? I mean, this is a term that IP and intellectual property and patents and trademarks and copyrights, and this is a term that is in the ethos that's thrown around. As an experienced patent lawyer, I can tell you it's thrown around improperly in many different ways. So it's it's one of those things where I think a little orientation can help with our discussion for today. So, and many of you will know what intellectual property is, so I apologize in advance for boring you, but essentially intellectual property is our thoughts, ideas, concepts, things that are created, innovations that are created from the human mind, intellectual, and then there are laws in place to protect those unique innovations and concepts, and it's grounded in our country, in the United States Constitution, and the laws have been developed over the course of time to provide legal rights surrounding each one of those innovations that come from our mind. And we have patents, which are inventions, which we will get into in more detail today. There are trade secrets, which also is information that comes from the human mind, and that have value in the marketplace. There are also trademarks and a unique, someone thinks of a unique branding approach, or a unique company name, or a unique name for a product. That's where trademarks come in to protect where the mark in the context of this identifying the source of the goods. And then there are copyrights, which is essentially authorship. And copyrights comes into play in a number of different ways. I mean, certainly we know in literature, and Gone with the Wind is protected by copyright, but it also comes into play in technology. With software, you can utilize copyright protections for software, and in other areas. But in the interest of time, we are going to focus our conversation today on patents and trade secrets, and sort of mostly patents with some trade secrets. I'll say that, and sort of how this relates to your company over the course of the life cycle of your company, how this all sort of integrates into what you're trying to do as an emerging company from the very beginning all the way until your exit or other desired goals. Okay, so we're going to cover 6 general areas here relating to intellectual property in your company over the course of a segment of your life cycle. The first subject that we're going to talk about is patent and trade secret protection. So first of all, what is in a patent application? A patent application, if you were to go into Google Patents or if you have maybe you're an inventor and you already have a patent under your name or an application, you find a sample of a patent, you're going to see a relatively, it depends on how much information is in there, but relatively lengthy, 10, 20, sometimes 30, sometimes 100 pages of information. And folks hold that up and say this is a patent, and it is. I mean, it's a patent application. It's a specification technically. And so what that sort of says, so let's take the 100-pager. The 100-pager is going to have probably 95 or so pages of the written description describing the invention. It's going to have figures that also describe the invention, and the written description is going to refer to the figures. And so there's the largest part of the content is usually involved directed to the written description and the figures or drawings. And this makes sense under the patent law, because in order to receive a patent, in order to be granted a patent, the deal is it's a quid pro quo. The government will grant you a 20-year term, 20 years from the date of filing your application, the right to exclude others from making and using your invention. And that's in the claims, which I'll get into in a second. But in exchange for those legal rights, the government here in the United States requires you, and around the world, I mean, the patent laws are fairly harmonized in the most fundamental respects throughout the major industrialized and other countries throughout the world. The exchange is you have to tell the public, you have to disclose to everybody how to make and use the invention. So if you tell us how to make and use the invention and you publish that, you get a limited legal right to exclude others for using that invention for a period of 20 years from the date of filing your patent application. So that's really the most of what's contained in that actual patent document that you sample that you will see. The claims are in terms of the legal right and in terms of the value to your company, the claims are the most important aspect of your patent application. And the claims appear at the very end of the document. And so you get that 100-pager, you go all the way probably to page 95 or even later, you're going to see a listing of claims. And the claims define what your legal right is. It's similar to they teach it in law school as a deed to property. And that's not a bad analogy. The words in the claim define the scope of your invention and therefore define the scope of your legal rights. The condition for getting a patent is whatever you're claiming has to be novel and non-obvious, and new and non-obvious invention. And what will happen is when you push that application through the United States Patent and Trademark Office and perhaps other patent offices throughout the world, the examiners, the governmental employees will look at the application, look at your claims, and then look at the vast swath of prior art that is out there. Examiners usually look first to patent applications and patents, issued patents as their source of prior art. But prior art can come from a number of different sources, including publications and reports and any websites and anything else that had been out there before you filed your application will be prior art to your application, and that gets put in front of the examiner. The examiner will take a look at the prior art, look at your claims, and then either issue a rejection or allow your claims. Usually they issue a rejection, and you argue over the prior art. That's just normally how the process goes. But in any case, we won't get too deep into that, but I did want to give some level of concept surrounding that, certainly what's in a patent application, but also what happens before the patent office. Now here is a timeline. This is an exemplary patent patent application process. There's no one size fits all, but this model right here is very typical. What I personally see and apply 9 times out of 10 when working with emerging biotechnology companies and other emerging companies. There is what's called a provisional application that you would file as early as possible to secure your priority to the invention. That provisional, and it's up in the upper left-hand corner, the US provisional application, and you secure your priority date. There's a 1-year period or 12-month period where, following the filing of a US provisional application, that occurs where you have the opportunity to effectively, you can let it pend for the entire 12 months and then you go to a non-provisional application, but you also have the option to file additional provisional applications within that 12-month period for any improvements that you make on your technology, which again, in an emerging company situation is usually very advantageous because it's normally a quickly moving space. There are certain technologies that are under development and are ongoing, and the emerging companies are normally pivoting and in terms of their fundraising and seeking to forge relationships with commercial partners, and so there's potential for disclosure, and which can harm your patent rights, and so getting something on file early is normally very important. But when that happens, the technology may not be fully developed, and so that's why the provisional process is very advantageous. And after you can file 2, 3, 4, 1 additional US provisional, no additional US provisional, but at that 12-month period, you would tie them all together and file what's called a non-provisional application. The deadline to file again is 12 months after you're filing your, wherever you're claiming your earliest priority, and you can file a US non-provisional application. You also have the opportunity to file a PCT international application. And the PCT international application is essentially a placeholder for your international filings, if that's a route that you choose to take. There are multiple ways to approach this. You can file a single US non-provisional and a PCT international application. You can file just a PCT international application and then designate the United States and go on the national stage. They call it the national stage entry after 30 months of your pending piece. After 30 months from your earliest priority date, you go into your national stage, and you to multiple countries. You can choose the United States as your country of entry. You can take that approach. And as well as other areas. There are also regional patent office like Europe. You don't have to file in every single European country. You can if you'd like, but a lot of companies will choose to file in the EPO, which is a regional patent office, and that gives you coverage over all of the participating European countries. There's also something called a Track 1 procedure, which is, you file a US provisional application, you pay a fee, a few $1,000s, depends on whether you can qualify as a small entity or not. But on the Track 1 case, you pay, and the patent office aspirationally seeks to provide you with a final disposition of your case within 12 months. Now, final disposition of your case is really a final rejection or an allowance. And you may get a final rejection, you may get an allowance, but the way we've seen this play out in practice is that the PTO does honor that, does give you an answer within the 12 months. So it does come to a final disposition. And the statistics at the USPTO indicate that that you have a slightly higher success rate when taking that approach. If you do not file a Track 1 case and you are in a U.S., you have a U.S. non-provisional, it's on a normal track, the prosecution is on normal track, and that could take 2, 3, 4, over 4 years, depending how the patent office is reacting to your application. And just, this is very not possible to fully cover, even if we just talk about this the entire meeting today. But I wanted to provide this overview to give you a sense of the process. This is an exemplary approach. There are multiple different ways to approach it. International filings, it's a very important decision that especially a young company makes. There is significant expense associated with it. Your multiple cost centers in different regions. However, that can be managed if you are strategic about it and know which countries where you think your patent claims will have commercial value. That is going to drive your decision making as to where you want to seek and obtain patent protection. I'm having some trouble with my slide here. Okay. So again, key patent protection considerations. You have a technology. It's an important technology. It's core to your business model. Timing is everything. You want to get that addressed right away. You want to confer with your patent counsel, and I strongly encourage that to confer with patent counsel, at least to get an orientation as to what your options are. You may not engage the patent counsel, or you may engage the patent counsel. That's sort of irrelevant to the initial conversation, which is, what is my status? What do I need to do here? And because the patent deadlines are largely unforgiving. If you disclose your invention before you file your provisional application, that can undercut your rights. That can destroy your rights in some cases. If you do that in the United States and it's over a year since you published a paper, for example, that relates to your invention or covers your invention, then that's going to be prior art against you, and you also could be barred from obtaining a patent as a matter of law. Some European countries do not have a grace period. That what I just described was a 1 year grace period in the United States, but in Europe, there are some countries don't offer that grace period, and other countries throughout the world don't offer that grace period. So you can seriously undermine your U.S. and international rights if you don't honor certain of these rules, these hard and fast rules that are pretty consistent throughout the world in the sense of there being a loss of rights for publishing. The timing and the safe harbors and those types of things vary. But sales, commercial activity relating to your invention, that can all undermine your patent rights. So without question, right up front, you should understand at a minimum, what is your if your technology is something you're going to protect, what the value is, but also what are these deadlines. And we want to make sure that, we're not doing anything that's going to run afoul of those deadlines. And oftentimes you're not only answering to yourself, you have partners and investors, and this becomes very important, especially down the road. I like to look at, I get excited about a company that's in a new space, or that's carving out its own niche in an existing space. And again, you want to align your patent approach to that. If you're in a crowded market, which, crowded 3, 4 other market players, maybe more, 2 other market players, maybe more. That's not crowded, but that's an active space. What is your differentiator in terms of your commercial go-to-market? Where are you carving out your niche? And is your technology a part of that? Is your technology differentiating you in that area? And if not, can you develop the technology that will differentiate you in that area? And then you build your IP around that. There's the first mover market, which is very exciting. I call it the blue ocean. It's not a term that I personally coined. If those that understand or read about blue ocean strategy, it's forgetting everybody else in the space and how they've been doing it, and then you see how to do it better, and then you create a new market, and that's when you can really establish yourself, obviously as a company, but in terms of your IP, you build around that and you go for broad claims, and then when the rest of the industry catches up with you and the larger players perhaps are trying to enter that space, and you secure broad claims, and that can be an incredibly valuable position to be in. Okay, so we talk a little bit about patents and trade secrets here, just to cover, again, we're focusing on those two buckets of IP, primarily patents. And this just provides an overview of the sort of differences and the background on each. The utility patent, which is the most common patent, that covers your your systems and your methods and your products. Those are utility patents. What's protected? Any new and non-obvious invention. Examples are chemical compounds, formulations, methods of administration, methods of treatment. The term, as I indicated before, is about 20 years from the date of filing. The reason why I say about is because if there's delay in the patent office, for example, between the time you file and the time that you get your patent, and the delay is caused by the patent office, you can get what's called a patent term extension. So that 20 years from filing has some adjustments associated with it, but roughly that is the case. I'll jump down to the bottom on design patents, just to talk about patents. Design patents are used to protect ornamental designs. How does that apply in the biotech space? A unique shape and design of a wearable, unique product packaging, those types of things are protected by a design patent, and a design patent's term is 15 years flat from the date of issue. Now, we talk about trade secrets, and this is a decision that companies, biotech companies in particular, often have to face early on as to whether a patent or trade secret. So that's kind of why I want to focus on this a little bit as well. Is the trade secret is any secret information that has commercial value. So examples: the Coca-Cola recipe. That's the classic example where they keep the recipe of Coca-Cola in a vault someplace, and no one knows what it is apparently. And the beauty, I guess, the beauty of a trade secret is you don't have a term. There's no limit to your term unless it goes as long as you can keep it secret under the applicable law. And I put it as an example here, the Colonel's secret recipe. And there's a link in the slide deck here that apparently the Colonel's Kentucky Fried Chicken secret recipe was kept as a trade secret. And then a reporter, I think from the Chicago Tribune or Chicago newspaper, interviewed one of the Colonel's long lost nephews, several years ago, and going through a scrapbook, the reporter took a photograph of a note that had, a listing of 11 herbs and spices in handwriting and other things. So if you have any interest in checking that out, go for it. It's I cook a lot, and admittedly, I did put this recipe together to see if it tasted like the Colonel's, chicken, and it was pretty close. I'll put it out there. It was pretty close. And so, but what happens then is, technically speaking, that secret is not a secret anymore. And so there's if that is indeed, and I'm not making a legal call here on KFC, but if they were claiming that it was a trade secret and it came out, then they would have lost their rights to the trade secret because it was no longer secret. Trade secrets can include manufacturing processes, testing methodologies, and many, many other types of information, including sensitive business information. So this is something you certainly want to do. You want to, cover with your counsel and internally to determine, how to inventory these different secrets. And we're going to talk about that as well. So can you keep a secret is the question. You have to take reasonable steps to keep the secret secret. As I indicated, you should inventory and mark any items that you believe are a trade secret as trade secrets. This can be difficult when you're dealing with things that are not physical documents. You can limit access. You can take different approaches as to how to do that. Limit access to certain data within your document management system. Limit access in terms of physical locations. Put up signage. Carefully craft your employee agreements. Employees are handling the trade secrets, because again, once it's out, and so you have to take reasonable measures to keep it secret. And if it comes out and you didn't do that, then you've lost your rights. If you did do that and someone wronged you, then you have a claim for theft of trade secrets. And so there's a balance there. There's also the issue of third-party non-disclosure agreements, what you tell another party. If you have a non-disclosure agreement that has a time limit of 3 years and your trade secret is part of that, there are cases that indicate that you didn't properly protect your trade secret because you put a time limit on when that trade secret could be, when there's no other contractual obligation for the party that received that information to keep it as a trade secret, and therefore, you lose your rights. And so you have to be careful with your third-party NDAs. They're not, and you don't always have to tell your partner everything. I mean, you have to be judicious about that, but you want to be very careful, especially if you think the trade secret is valuable. This is an area, trade secrets is a creature of state and federal laws. There are federal laws, but there's also state laws that apply. And, as you likely know, state laws aren't always the same and uniform. So depending on where the information is, where you are located, that will sort of drive your approach to protecting your trade secrets. Okay, so we will go to our, touch on these different issues, the employee IP assignment agreement. Employees and founders, when you found a company, you have, maybe it's yourself, maybe you have multiple one or more founders. You will want to, and you form a company. That's in the formation stage, and that's in the founding stage. You should, the strong recommendation is you should have an agreement amongst each of the founders that they are going to assign any intellectual property that's generated, assign that to the company. Now, that isn't always the case. Founders have, can agree to what they want to agree to. And so that may, in the circumstances, may be fully justifiable why not to do that. I think the general recommendation, though, is if you want your company to have value, your company is going to have to or should own the intellectual property, because that is a key asset for an early stage company. Going forward, when employees come on board, there should be an employment agreement, which requires the employee to assign their IP to the company. And there's also a non-disclosure agreement. And there should be also a non-disclosure agreement with employees on a going forward basis, and then which include a number of things, including processes for what happens when on termination, what happens when coming from a competitor, going to a competitor, those types of things. But you certainly want to have an agreement in place that relates to those issues. Certain state laws have, states have started to pass these laws which give a boundary of protection that companies and institutions don't overreach, where if an employee invents something, but that's not within the scope of their employment. For example, there are laws that statutes that have been put into place in multiple states, including Massachusetts, that give employees some rights. Some states have gone to the opposite direction, indicating that it's a presumption that the company owns the IP. I'm not remembering the exact. I saw one state statute, that has that those types of terms, and I'm not remembering the name of the state, but there is one out there, at least one out there. So you want to be aware and cognizant of what what the law is and what the scope of that law is. There are joint inventorship issues that come into play with founding and when you're employees. If you have two employees that invent something and they have their name on a patent application, and there's no IP assignment agreement in place, by operation of law, those employees co-own the patent and the company doesn't. And so, hopefully nothing, if that's the search situation, it's not a good situation to be in. Hopefully nothing comes of it. And when you get to the point where you're prosecuting the patent application, the employees will assign their rights to the patent to the company, but that isn't always the case. Employees, the relationships change over time, and it can be very difficult to explain to an investor when you have two employees that are joint owners that are no longer with the company. They're maybe even with a competitor. They are, legally the co-owner of a central asset that you have in your company. It can be a real mess. And so you really want to get these things addressed early on. Okay, internal IP policies. We've talked about this a little bit, I think, just to go over it very quickly. So your company will, you should implement and consider intellectual property related policies, including your invention disclosure process. What happens when someone comes up with an idea that's potentially patentable? Do they write it up in an invention disclosure form? Usually that's the case. That's not always the case. Where are their notes kept? Where are the, what is the process for when an employee invents something? There's trade secret protection policies, which we've touched upon, as to how to, you want to inventory the trade secrets. You want to, label areas. You want to restrict access. There are all these things that items that you should consider when you're implementing your trade secret protection policies. There are open source software policies, how to manage open source software and related agreements. This is not really necessarily an IP area, but document retention. What are your document retention policies? How often, do you keep electronically stored information that's not necessarily relevant to your ongoing business? What do you do with your tax forms? Keep them forever. But there's all these things that you should hammer out early on, and then what are your standard NDAs? And they're sort of, and then you get into other documents. But in any case, whatever the policies are, do it right up front, and then just follow the policies. And that's going to save a lot of liability, issues that could arise later. And it's a smart approach to develop these internal policies. And like when I write this, it's not like you're not doing a novel for each one of these things. I mean, it's just some of these policies could be a page in length in terms of like the invention disclosure policies. Your trade secret policy may be 4 pages. But it's just having it in place, and then having your team and your employees sort of aligned with it, and then you become a sort of well-oiled machine, and then you mitigate any potential issues that might arise later. And that's what you're preparing for. You're doing it now to avoid the problems and the liabilities that come up later. Okay, so licensing and collaborations. This is a key area. your partnerships that you forge in, when you start to build your IP portfolio, or you in-license your IP portfolio, there are a number of issues that can come up. When you're in licensing, a lot of times, especially in our ecosystem here in Boston and Cambridge, the startup in licenses legacy university technology. And in that situation, you are forging a hopefully an exclusive license with the university on the legacy tech or the founding tech. And you strike a deal with your tech transfer, the tech transfer office of an institution, whether it's where you were working, or whether it's where one of your founders were working, or whether it's where you're licensing from. And you need to be cautious there as to what types of provisions, if there are onerous provisions and fees and triggering events and restrictions, and don't allow you to own any new IP. There are a lot of things that are at play in those types of deals, and so the recommendation is to again to consult counsel or consult someone someone that's done this a lot, and usually it's counsel in a different number of different circumstances and different technologies. Then if you have your own technology, or if you're technically sub-licensing the legacy technology, but we're using this example here of starting a company based on university generated technology. Say you work it out in the license agreement where you're able to own any IP, the company is able to own any new IP that is generated, and you develop important new IP that is solely owned by the company. That can be exciting because you're now independent. You're independent of the university. Again, in just this example, you're generating your own IP that has value that you can license if it's valuable in the market, and other players want to utilize the technology. You out license that, and that can be a revenue generator. You also have I'll jump to the bottom real quick, is the larger partners. You're dealing with some larger partners. It can be a very big deal for you to, if you're a small company, to partner with a much larger company that's known in the space, and that gives you credibility that can help you raise money. The downside is you're negotiating leverage, and this slide right here could be an entire talk. So I'm going to quickly jump through the rest of these points. Exclusive, non-exclusive fields territory. When you have intellectual property, when you have a patent, you have a bundle of rights, and those bundle of rights you can parse out those bundle of rights however you want. In the licensing agreement, you can break the rights into pieces as well, and the spaces of whether you're granting an exclusive license, a non-exclusive license, whether you're in a certain field, a certain therapy field, certain disease field, territory, United States, worldwide. There are a lot of ways to do this, and you want to be strategic about how you dole out your rights. And there's different types of agreements too. Other beyond licensing, it's development and commercialization agreements where you may have developed a technology and you want to further develop the technology, but you need a larger entity to help champion and commercialize that technology. I think a good example of that is the company BioNTech, which is an mRNA pioneer that partnered with Pfizer for its distribution of the COVID-19 vaccine, and they needed Pfizer for the infrastructure that they had in the vaccine space, and for a whole number of other reasons. So getting to the end here, we can talk briefly about patent enforcement. When you get a patent, when you're granted a patent, again, that gives you the right to exclude others. Well, other players in your space may also have a patent, which gives them a right to exclude others. And that means they have the right to exclude you from doing things. And so there's an offensive and defensive posture to patent rights. And FTO here on the slide stands for freedom to operate. You really want to have a very close understanding of what the competitors are doing, what their IP is, what their activities are. If they're a publicly traded company, there's maybe no better place to look than the publicly filed SEC statements that they're required to disclose to their investors what they're doing. They're required to disclose their patent position, their IP position, and they disclose it. They're required because for, to give the investors an idea of where their patent position is. And so and that's a good place to start, I should say. And you really want to keep an eye on and understand what the potential liabilities that you might have operating in the space. But through that process, you will also gain a strong understanding of both the market and where the technology is. And that's really where if you sharpen your pencil and your team goes to work on that, you can really differentiate yourself in the market, because you can understand where the market, you might be able to tell where the market is headed, where the science is headed, where the tech is headed. But people, other competitors may not be there yet. As a small company, you have an advantage of being nimble, and the larger companies are not so nimble. They're giant. Some are giants, and they're not going to be able to be as maneuverable as you are, and find those niches that are doubtless there in the market. And so you really going through the process of understanding what your competitors are doing, not obsessing over them. I mean, you want to follow what your mission of your company is by and large, but just having an understanding of what the space is. I think that's maybe a better way to say where is the space and how am I positioned in the space, and how can I get advantage of the space? Well, you can do that from a business perspective, but then also from an IP strategy perspective, because when you get the protection around areas that other competitors are going to need to play in, or spaces they're going to need to play in areas, then you have immediate leverage. And that isn't necessarily for an enforcement. There's always the ability to enforce the patents, but it oftentimes can lead to a licensing deal, and then also helps when you're seeking to be acquired in whatever your exit is. We'll get into that in our last slide. But if you do get into a patent action, there are a number of venues that hear these patent infringement cases in the United States District Courts. Number one, the International Trade Commission, which does not issue damages, but its ITC is located in Washington, D.C., and you can prevent the importation of products into the United States through enforcement, through an enforcement action, a complaint before the ITC. The Border Control is the group that will enforce that, exclusion order that you get as a result of a successful ITC action. It's not really enforcement, but there are these procedures at the USPTO, inter-party review proceedings, where you can seek to invalidate if we're doing in terms of a competitor patent, you seek to invalidate a competitor patent, and you ask the United States Patent and Trademark Office to look at this patent again. We think it was anticipated. We think it was obvious. USPTO, this patent is standing in our way. Look at it again, and and issue a ruling on whether it's invalid. We think it's invalid. Please, let's go through this IPR process to determine whether it is invalid or not invalid. So that is interesting. In terms of the expense, a U.S. District Court litigation will range anywhere from beginning to end in the millions of dollars. I know that's maybe a little bit surprising, but it's not just the legal fees. There are expert witnesses. There obviously are attorneys. There are other expenses involved, and if this takes course over a period of 3 years, it's really it makes a lot of sense as to why those are so expensive from start to finish. Now you can settle and enter into have it as a licensing play, and to try to come into a license agreement, and that would end the litigation. But from the beginning through trial, they can be very expensive. And the ITC is a shorter period of time, and it's just as expensive, if not more, but it's truncated in the course of about 16 months. So these are things that there is litigation financing, and this. So I just wanted to post this in enforcement slide just for your information, and then we'll move on to the last major consideration, IP consideration, which is your funding and exit. It is the first question asked, usually, especially in biotech. One of the first questions asked, what is your IP position? What is your patent position? Have you filed for any patent applications? If the answer to that question is no, it's significantly important answer, because that can cause some investors to raise eyebrows, and that can hurt you. If you answer the question yes, that has the opposite effect, because it mentally, initially at least, checks a box in the mind of the investor, as to, okay, they've got something filed. Now you're going to get those follow-on questions later on. You can't just file something that's not worth very much. That's not going to get you very far. To get you past the first few conversations, but eventually your investors are going to know what your position is, because you're going to tell them. They're going to ask you, and you're going to tell them. And this will be scrutinized during your growth. It'll be looked at. It'll be considered. And so having a strong IP position, especially in the biotech space, is very important for your funding efforts. Again, and that's not to be to scare anybody per se, because there's an optimistic side to this, which is if you really have a differentiation in the market, and you properly built your IP around that differentiation, that's a huge plus factor for an investor, because the investor is going to see your team. You're great. You got a great leadership team. They're going to see your technology. They're going to understand why it's different and how valuable it is, and how, when you go to market, and what those numbers could look like, and you've got it protected with IP. That can be a huge plus factor, and that factors into the value of the company, the real bricks and mortar value of the company, your valuation as you go through your funding rounds, and then gives you leverage when whatever you're trying to do, whether license or exit and sell the company, or whatever your next steps are. So this is the summary slide. I think that I'd like to keep this slide up if possible, and then open up to questions here for the time that we have remaining. And thank you.